Let's look then to piercing the corporate veil in Hong Kong. This is sometimes referred to as lifting the veil. It's also referred to as disregarding the corporate entity. Occasionally, you'll see scholarship making a distinction between these three words, but for the common law, it is possible to use all terms interchangeably, and piercing the veil is the term which is used most generally. So we have the company which may be innocent, or it may be not innocent. The leading case in Hong Kong is China Ocean Shipping versus Mitron's Shipping Company. And in this case, we have at least two companies using the name Mitron's. And one is in Panama, incorporated, and the other is incorporated in Hong Kong. This has to do with also business with North Korea, and that's one of the reasons why the Panama company is being used at this point. But the Panama company then does not comply with the contract and is sued. The plaintiff finds that the Panama company has an office in Hong Kong together with Mitron's Hong Kong. It finds that the officers of the Panama and the Hong Kong company are more or less identical. It finds that the Panama company is not registered as a so-called non-Hong Kong company. Also finds that the officers of the Hong Kong company respond to correspondence addressed to the Panama company. Right? So we have essentially what can be clearly referred to as an alter ego. That is, Mitron's Panama is essentially another half of Mitron's Hong Kong, except for the fact that they are two corporate entities established under two different bodies of law, and therefore have a distinction between them as registered as separate companies in separate corporate company registries, one in Panama and one in Hong Kong. Right. So do we look to the substance, that is, that these two companies are essentially run by the same people at the same place and merging their business, or do we look to the form? Remember that Mr. Solomon was also more or less the sole proprietor. In the decision by Justice Bokhari, what we have is the leading rule on when to pierce the corporate veil. And he says essentially that using the company limited by shares form to evade liability is something that will lead to piercing, but using the company limited by shares form to avoid liability is the natural and intended use of that form. So it comes down essentially to a distinction between the words evade and avoid. And there is a distinction in English between the two. But beyond that distinction in the English language, we can build on the legal distinction as found in the common law. So avoiding would be something to which we do in advance, like taking an umbrella if we think it's going to rain, or raising our hand if we see bullets coming at us in the Matrix. Evade would be something like we have a tax liability and we move funds offshore, like Starbucks or Google or Apple do in the United States, moving funds to Ireland, the Netherlands, or the Cayman Islands in order to evade U.S. taxation. We also talk about evasive action in warfare, and this would be essentially dodging. And we also refer to persons who evade taxes as tax dodgers. Dodging, there's a game that children play called dodgeball. You might be familiar with that. And that's essentially this kind of thing that we see, although a larger ball is used. This is in cricket. But essentially, here the player is dodging the ball that might have hit him in the head or the shoulder. This is evasion. So that brings us to a more recent case, Winland Enterprises. And Winland is a Court of Appeals decision, relatively recent, 6 years old, in Hong Kong. And in Winland, we have a defendant, which is essentially a Barbados company, but then a defendant which is added to that defendant, which would be a Canadian company. So the parallel to Mitron's, the action should be against a Panama company, but the plaintiff includes a Hong Kong company attempting to pierce the corporate veil and say that essentially the Panama company is the Hong Kong company. And here, the actual plaintiff is the Barbados company, and the plaintiff is asserting that through piercing the corporate veil, the Canadian company should be liable. Right? So we have an agreement between Winland, a British Virgin Islands company, and the Barbados company. The Barbados company is a subsidiary of WEX, which is a Canadian company. WEX has another subsidiary, Nanning, which is producing a drug referred to with the name tetrodin. And tetrodin is something that can be hopefully used to cure addiction to opiates. And in this case, there's an intention to use the drug in Peru. That's the flag at the bottom of the page. Use this tetrodin in Peru to cure addiction to cocaine. Tests show that tetrodin actually turns out to not be as successful as WEX had hoped. WEX and Acropharm contact Winland to explain that they would like to restructure the agreement or actually eliminate the agreement. Winland then sues on the basis of the agreement and includes WEX as a defendant in this action. Originally at the lower court, we have an inclusion, but then that is rejected by Justice Anselmo Reyes, and then this is appealed. And in the Court of Appeals, we find the Mitron's test applied. Essentially, coming from Solomon through Mitron's into Winland, we have the rule that the corporate veil will not be pierced, save for one particular kind of situation. And this situation we see in a number of UK cases and also in Mitron, right? So we have in Guilford a liability which is shifted to a company to avoid a non-compete agreement. In Jones, we have an asset which is then shifted to a company in order to evade a commitment to sell that asset. And then in Creasy, we have a company set up after liability is incurred in order to evade payment on a judgment. So all of these cases are evasion, and all of them have to do with time. It's a very simple question. One looks at the time when the liability arises, the time when the use of the corporate entity arises, And if the liability precedes the corporate entity, we have evasion. And if the liability comes after the creation or use of the corporate entity, we have avoiding. Evasion leads to piercing the corporate veil. Avoidance does not. When you are looking at the cases, you'll see a number of different facts being discussed, and I'll just give you some guidance on those facts. So for alter ego, the idea that the company is actually the alter ego of the member, and there is no distinction because they're two halves, two sides of the same whole. This sounds impressive to people that don't know company law. It sounds mysterious using psychological terms, but this was already discussed in Solomon. And at the time of Solomon, it was possible to set up a company only with 7 members. Today in Hong Kong, we may set up a company with 1 member. And so certainly a company can be the alter ego of that member if that member is the only member, the only director, the only employee. It will look very much like an alter ego. That is not a problem. That's what the law is for. A disregard of formalities, we have this in mitrons. And in mitrons, it's not an extreme disregard. I wouldn't exclude the possibility that a disregard of formalities, if every single formality that applies to a company is disregarded and the company is treated as a kind of a private piggy bank of the member, then that could potentially lead to a piercing of the corporate veil. But there is no clear precedent for that. What we do have a clear precedent for, from Erlanger until now, is that fraud or misrepresentation can lead to piercing the corporate veil. And often this will occur in a case which is actually the same as evasion. Undercapitalization is the problem. And undercapitalization is why we want to pierce the corporate veil, because the victims are not being compensated, and we need to see them compensated because we like to see justice served. So undercapitalization will almost always be present, but undercapitalization itself is not sufficient to pierce the corporate veil. Because, as I said, we wouldn't even have a case, it wouldn't even be discussed unless undercapitalization was present, because if the victim or the contract creditor was fully paid, they would not be trying to pierce the corporate veil. And then lastly, in timing, this is essentially the core problem of evasion, as I said. This is the problem where the liability exists, and then the corporate form is somehow used after that. Either a new company is set up, assets are shifted into a company, or other aspects of the company's existence are used in order to evade payment of the liability. And so where you see this problem of timing, which will often overlap with fraud or misrepresentation, these are cases where we have evasion, and in Hong Kong, these are cases where we may pierce the corporate veil.